Hello class, this is Chapter 1, Criminal Law and Punishment in U.S. Society, an overview. The learning objectives we're going to cover in this chapter are as follows. To know the dual nature of the social reality of U.S. criminal law and to understand how it reflects both our criminal law and punishment imaginations. To understand the differences between criminal and non-criminal sanctions and to know the purposes of each. To understand the various ways to classify crimes and appreciate the legal and social ramifications of these labels, and to identify, describe, and understand the main sources of criminal law. We will also define and understand what behavior deserves criminal punishment and to understand the social consequences of the era of mass imprisonment. To know and understand that the main theories of criminal punishment center on either retribution or prevention, and to appreciate the large complex body of empirical research supporting each. And finally, we will work to understand the text case method and how to apply it to the study of criminal law. The dual nature of U.S. criminal law has divided into two categories, a small number of serious core offenses and a large number of lesser crimes or everything else. The contributions of law, history, philosophy, the social sciences, and sometimes biology to explain the moral desires we wish to impose on the world are what make up criminal law imagination. We have core felonies, which are felonies against persons. Those include manslaughter, murder, rape, kidnapping, and robbery. And then we have felonies against property, which are the core offenses of felonious theft, robbery, arson, and burglary. Crimes that fit within the criminal law imagination and the law should be punished by locking people up. Then you have all of the rest of criminal law, or the police power. When it comes to police power, all federal, state, and local governments, executive, legislation, and judiciary's power, including uniformed police officers, are there to carry out and enforce the criminal law. We will talk about the history of that and the public morals that are involved. Crimes and non-criminal wrongs represent two different ways our legal system responds to social and individual harms. Non-criminal wrongs are called torts. Torts are private wrongs for which you can sue the party who wronged you and recover money. You see that on the right side of this slide. There are similarities between crimes and torts. Both are sets of rules telling us what we can't and must do. These rules apply to everybody in the community and they speak on behalf of everybody with the power and prestige of the whole community behind them. The power of the law backs up their enforcement. The injury involves the entire community and individual or individuals. There are differences between crimes and torts. There are two forms of social control are the torts and crimes. Convicted offenders pay the government or serve time in custody of the government. Defendants in a losing tort case pay money to the plaintiff who sued. A criminal conviction is a condemnation by the whole community. Tort awards are compensation to the plaintiff. The state has to prove all elements of the crime by proof beyond a reasonable doubt, and that's for criminal law. And then you have burden of proof for plaintiff, and a requirement for the tort is a preponderance of evidence. There are various ways of classifying crimes. One way is to divide them into two categories. You have mala in se, which are inherently evil crimes that are offenses that require some level of criminal intent. Examples would be murder and rape. Mala prohibita offenses, which are crimes only because of a specific statute prohibits them. Some examples of those would be parking tickets or drinking in public. The most widely used scheme to classify crimes by kind of crime and punishment are felonies, which are crimes punishable by death or incarceration by the state for a year to life without parole, and misdemeanors, which are crimes punishable by fine and or incarceration in a local jail for up to 1 year. The label of felony or misdemeanor matters because of different procedures for the different crimes. Felony defendants are required to be in court for their trials, and misdemeanor defendants are not. Prior felonies make offenders eligible for longer sentences, and the legal consequences for felonies are also longer than they are for misdemeanors. Now here's an activity for you to do. Read the following scenarios and determine what level of offense was committed. First, a 20-year-old male was sentenced to prison for 15 months. What level of offense did he commit? Second, a 36-year-old female was released from jail after serving her entire 280-day sentence. What level of offense did she commit? Third, a 27-year-old female appeared before the court and was informed if convicted of the offense that she's been charged with, she could serve no more than 365 days in jail if convicted. What level of offense did she commit? Next, a 45-year-old male was released from custody after serving a 48-month sentence. What level of offense did he commit? And finally, a 55-year-old male was ordered to pay a fine of $300. If he does not pay, he will have to serve 90 days in jail. What level of offense did he commit? When it comes to sources of criminal law, throughout U.S. history, reformers have called for the abolition of common law crimes and their replacement with criminal codes. Hostility towards England was one reason for reform. Reformers also contended with judge-made laws that were not just disorderly and incomplete, they were also anti-democratic in nature. Criminal law was created by elected representatives in state legislatures. The first state criminal codes were created in 1648 in New England and codified for the colony's criminal law. During the strong codification movement in the 19th century, two codes stand out. The first are Livingston's draft code for Louisiana, completed in 1826. It was ambitious but not overly successful. Livingston's goal was to rationalize into one integrated system: criminal law, criminalized procedure, criminal system, criminal evidence, and punishment. Then you have David Dudley's Field Code, which was less ambitious but more successful. So he was a successful New York lawyer who wanted to make criminal law more accessible, particularly to lawyers. The Model Penal Code was a proposal legal code adopted by the American Law Institute and used to reform criminal codes. Adopted in 1962, and 40 states ended up changing their criminal codes as a result of the Model Penal Code. It was influential on all state criminal codes. Understanding the MPC allows one to understand criminal law. The MPC defines criminal liability as, quote, conduct that unjustifiably and inexcusably inflicts or threatens substantial harm to individuals or public interests. Then you have municipal ordinances. These are criminal law created by the city and town councils elected by city residents. City, town, and village governments enjoy broad powers to create criminal laws and use this power enthusiastically. It often duplicates and overlaps state ordinances. Unless state ordinances make it clear that they preempt local ordinances will remain in effect. The power of local governments is not limited to law but includes determining punishment as well. Although municipalities have broad power, they are also limited by the Constitution and state law and punishment. Then you have the U.S. Criminal Code. This is criminal law created by the U.S. Congress. It covers more conduct than most states and municipal codes. You have administrative agency crimes. These are administrative agencies appointed by participants in creating criminal law that assist in the U.S. Congress. That would be things like the FBI or the ATF. Administrative crimes are violations of federal and state agency rules that make up a controversial but rapidly growing source of criminal law. Then you have informal discretionary lawmaking. This is determined by criminal law enforcement agencies. These create criminal law through informal discretionary law, making up and deciding how criminal law process works on a day-to-day basis. Now here's an activity for you. Is this a criminal offense or a municipal ordinance? Read the following scenarios and determine whether the act would be a criminal offense or a violation of a municipal ordinance. First, a teenage boy was found in the park at 11:15 p.m. City curfew is at 11 p.m. Second, an elderly woman intentionally exits a retail store pushing a cart containing shoes, groceries, cleaning supplies, and a TV without paying for the items. Third, an adult female is walking down the street with an open container of alcohol. And fourth, while backing out of a parking spot, an adult male hits and severely injures the child exiting the vehicle next to him. It was determined that the adult male was under the influence of an illegal substance. Now we're going to talk about criminal law in the U.S. federal system and help define and understand what behavior deserves criminal punishment and to understand the social consequences of the era of mass imprisonment. In our federal system, there are 52 criminal codes, one for each of the 50 states, one for Washington, D.C., and one for federal criminal law. The U.S. government's power is limited to crimes specifically related to national interests. These are crimes committed on military bases and other national property, crimes against federal officers, and crimes that are difficult for one state to prosecute. For example, drug, weapon, organized and corporate crime, and crimes involving domestic and international terrorism. All other law is left to the state codes. Defenses and punishments vary widely across the states. The United States has less than 5% of the world's population, but it accounts for almost 1/4 of the world's prisoners. The era of mass imprisonment started in the 1970s up to the present. Part of it was because of the social and political upheaval of the 1960s. After 40 years of rising incarceration rates, the crime rate fell. But it is difficult to evaluate the consequences of prison on crime. Most studies conclude that more prison has reduced crime, but can't say by how much. There is a problem with massive imprisonment in our poorest communities. That produces possible negative consequences. There are recommendations by the National Research Council Committee on causes and consequences of high rates of imprisonment, and those include proportionality, parsimony, and citizenship, and social justice. This is the world imprisonment rate as of 2009, and this is figure 1.2 in your text. And you can see quite plainly that the United States has more people incarcerated than any other country in the world. Now let's talk about the definition of criminal punishment. In order for punishment to be considered criminal punishment, it must meet 4 criteria. These criteria include penalties that A. inflict pain or other unpleasant consequences, B. prescribe a punishment to the same law that defines the crime, C. are administered intentionally, and D. are administered by the state. The differences between treatment and criminal punishment lies in the purpose of it. Pain may be inflicted as an unfortunate side effect in treatment, but it is inflicted for the purpose of punishment in criminal punishment. The thinking regarding the purposes for criminal punishment has long been divided roughly into 2 schools. You have the retributionists, who believe in inflicting on offenders physical and psychological pain or hard punishment so that they can pay for their crimes. Retribution is a basic human impulse. It looks back to past crimes and punishes individuals for committing them because it's right to hurt them. Punishment is good for society and for criminals. Society pays back criminals by retaliation, and criminals pay back society by accepting responsibility through punishment. It's only right if offenders choose to commit their crimes. Some appealing qualities are that free will, if it is in accord with the human nature, and it has ancient roots, and rests firmly on 2 philosophical foundations, culpability and justice. Opponents of retribution argue that there are a number of problems with retribution. It's difficult to translate abstract justice into concrete penalties. Retaliation is not part of a civilized society. Determinists reject the idea of free will completely. Most crimes don't require culpability to qualify for punishment, like public order and moral crimes. Preventionists believe that punishment is only a means to a greater good, usually the prevention or at least the reduction of future crime. Prevention looks forward and inflicts pain to prevent or at least reduce future crimes. There are 4 kinds of prevention. You have general deterrence, which aims to prevent the general population who haven't committed crimes from doing so. Specific deterrence aims to prevent convicted offenders from committing any more crimes in the future. Incapacitation prevents convicted criminals from committing future crimes by locking them up, or more rarely by altering them surgically or executing them. And rehabilitation aims to prevent future crimes by changing individual offenders so they'll want to play by the rules and won't commit any more crimes in the future. Let's talk about prevention. You have general deterrence, which the idea is to punish the offender to make an example of them and thereby deter others from committing future crimes. This was written by Jeremy Bentham, and he was the author of the deterrence theory. And he wrote about rationalism and hedonism. And you need to study this a little bit more in detail in your book. The criticisms of deterrence theory are that there is emotionalism surrounding punishment which impairs objectivity. Prescribed penalties rest on faith. Rational free will that is underlying deterrence theory does not exist. Behavior is too unpredictable to reduce to a mechanistic formula. Threats of punishment don't affect all crimes or criminals equally, and deterrence is unjust because it punishes for the sake of example only. As far as incapacitation, preventing future crime by making it physically impossible for the offender to harm society at large includes incarceration, which is locking people up so they cannot harm society, altering them surgically or chemically to make them incapable of committing their crime or executing a person. There are criticisms of incapacitation. Incarceration shifts criminality from outside prison to inside prison. Violent offenders continue offending in prison, and property offenders continue also. Incarceration is generally temporary in nature. When it comes to rehabilitation, there is determinism, which are forces beyond an offender's control that can cause them to commit crimes. That can include people that are mentally ill, for example, where there's no choice made by the offender and you can't blame the offender. Therapy by experts, however, can change some offenders. There are criticisms of rehabilitation, however. It can be based on faulty, unproven assumptions. The causes of crime are complex. Human behavior is not well understood. Sound policy can't depend on treatment. It makes no sense to brand everyone who violates the law as sick and needing treatment. And inhumane cures justify large quote-unquote doses of pain. When it comes to empirical evaluation of criminal law theories, there's a great deal of research, and it's complex. The more complex, the less likely practitioners are to read it all. We're going to talk now about the text case method. The text part explains the general principles of criminal law and the definitions of specific crimes. The purposes are to help you understand the principles and elements of specific crimes. It also stimulates you to think critically about the principles and their applications. There are essential points about verdicts. A not guilty verdict doesn't mean the person is innocent. It means the government didn't prove its case beyond a reasonable doubt. A guilty verdict doesn't mean not innocent. It means the government proved its case beyond a reasonable doubt. When it comes to criminal cases start in trial courts. Appeals are rare. Appeals go to appellate courts. And the cases in the text come from appellate court excerpts. The parts of the case excerpts are the title, citation, the procedural history, the judge, the facts involved, the judgment, and the opinion, which includes the majority opinion, dissenting opinions, concurring opinions, and the plurality opinions. These excerpts are edited versions of appellate court decisions, but not full trial transcripts, and they're not from cases where the defendant was acquitted. Some case law terminology you need to become familiar with are trial court, not guilty verdict, acquittal, and conviction. Trial court is where trials actually take place. A not guilty verdict is not innocent. It just means the person was not found guilty. In other words, the government did not prove their case beyond a reasonable doubt. You have acquittal, where someone is completely cleared of all charges, and conviction, where the case was proven beyond a reasonable doubt. The person was found guilty. Here's an activity for you. Find a case at the Supreme Court website below. This is www.supremecourt.gov. Brief the case and discuss the importance of each section of the case brief. Study the case and try to understand the elements of the text case method and how they apply to the case that you discover. Continuing with the text case method, the parts of the case excerpts used are the title, the citation that the person was cited for. A case citation is a system used by legal professionals to identify past court case decisions, either in a series of books called reporters or law reports, or in a neutral style that identifies a decision regardless of where it is reported. It also includes procedural history, the judge involved, the facts of the case, and the ultimate judgment or decision. Continuing with the parts of the case excerpts, you have the opinion of the court's holding, and the holding is the court's determination of a matter of law based on the issue presented in a particular case. In other words, under this law, with these facts, this is the result. Then you have the court's reasoning. You have the majority opinion, where the majority of judges rule, and you've heard this in the Supreme Court, like in a 5-4 ruling or a 6-3 ruling, etc. Then you have a concurring opinion. In law, a concurring opinion is in certain legal systems a written opinion by one or more judges of a court which agrees with the decision made by the majority of the court, but states different or for additional reasons as for the basis for his or her decision. When there's no absolute majority of the court that can agree on the basis for deciding the case, the decision of the court may be contained in a number of concurring opinions, and the concurring opinion joined by the greatest number of judges is then referred to as the plurality opinion. Then you have the briefing of the case excerpts. You have the facts, the acts of the defendant, the intent of the defendant, the circumstances involved, causing a harmful result, and justification and excuse defense. As far as the legal issue in the case, you have the court's decision, which is affirmed. It can also be reversed, like in an appellate court, or reversed and then remanded. When something is reversed and remanded, let's say a case is sent to appellate court for an appeal, of course, it can be reversed and then remanded and sent back to the court of appeals, or sent back to its original court. So that's what it is to be not just reversed, but also remanded. A key case that's important is Bond versus the United States, 2014. Bond was convicted in U.S. District Court of Eastern Pennsylvania of possessing and using a chemical weapon and mail theft. Her sentence was 6 years in federal prison, plus 5 years of supervised release and a $2,000 fine and $9,902.79 in restitution. Bond appealed. The Court of Appeals for the Third Circuit affirmed. Bond petitioned the U.S. Supreme Court for a writ of certiorari. The Court of Appeals for the Third Circuit affirmed. The Supreme Court reversed and remanded. The Court of Appeals again affirmed Bond's conviction. The Supreme Court reversed and remanded again. The Supreme Court held that federal law typically does not intrude on the ability of states to regulate local matters, and the Chemical Weapons Conviction Implementation Act is not an exception to that general rule. So you can see how when this case went to appellate court, it was affirmed, reversed, remanded, reaffirmed. So that's how that process works. So this is an important case, Bond versus the U.S. Class, thank you so much for your time and attention. We'll meet again in Chapter 2. Please make sure to contact your instructor if you have any concerns or questions about anything that we covered in this chapter.